welcome back to Litigation Help. My name is Heather Hoyt-Twin, and today we're going to talk about urgent motions in family law proceedings. For example, let's say that you think your ex is harming, abusing your child when they're in their care, and you want to get a court order that would grant you sole decision-making and parenting time. How would you go about doing that? So joining me here today is our regular guest, Helena Birt, to give us some information about urgent motions. Hi, Helena.
Hey, Heather, how are you?
I'm
Welcome to
great.
the
How
new
are
year.
you? Happy New Year. Yes. But before we proceed, please note that these videos are based on the law in Ontario, Canada. So it should be taken as general legal information only. For advice specific to your case, please consult with a family lawyer. So, Helena, could you give us some background information about what urgent motions are?
Generally, whenever you're looking at starting a family court proceeding, well, any court proceeding, there are the family law rules set out what the normal process is for how a case is going to progress.
Right.
If you have a recent separation and you can't work out an agreement and one of you feels you have to start a court proceeding, we've done the videos on how to bring an application and what the steps in the process are.
Right.
The way the family law rules are set up is that you start your application, then you go through, the next step would be the first appearance before a clerk. Your first time you're before a judge is at a case conference. That's a key point to remember for this purpose. And then you can have a settlement conference and then a trial management conference. And at every conference stage, the parties are meeting with the judge who's there to see if there are any issues that can be resolved on consent and to narrow down the issues that have to go to trial. If you get to the trial management conference stage, that means that there are issues that are going to have to be dealt with by trial. And that trial management conference is for the purpose of figuring out how long is the trial going to take, what evidence are the parties going to be calling, are there any documents that have to be filed, are there going to be any expert reports or witnesses, and all that has to take place. Because of these multiple steps, and because of how busy the courts are, the process from the time a party starts an application until they finally get to trial, assuming they can't get everything on consent, can be sometimes over 2 years in length. And usually there is a need for a temporary order to be put in place when parties have separated, just to get the situation settled down. If the parties can't agree about how much time the children should be spending with each parent, about child support and all those things, the way that you can deal with those to get a temporary order in place is by bringing a motion. So you can bring a motion in an application to obtain a temporary order that is just meant to be in place until you actually have your trial, at which point after the trial, a final order is made. Okay? And generally, what the family law rules do say is that if you wish to bring a motion for a temporary order in a family law proceeding, you cannot do it until you've had your first case conference with a judge. So, because again, they want to try to use the court's time for the things that are really, really important and that really, really need it. And so the general rule is that in a family law proceeding, you can't bring a motion for any kind of temporary order until you've had that first case conference with the judge. So the judge can sit and meet with the parties, talk to them about what the options are, see what the parties have been considering. Somebody could be going off on a tangent where the judge says, look, you're not going to get very far on that. You might want to rethink your position. So that's the way that works, is that you generally cannot bring a motion for temporary relief until after you've had your first case conference with a judge. Once you've had that case conference, either party can bring a motion if they feel they need to because they haven't been able to reach a consent for a temporary order, or that they know they've got a real fight on their hands and they need to bring it to court to sort it out. The same applies if you're doing a motion to change. So if you might have a final order in place and there are things that need to be changed in the final order, then you can bring your motion to change. And the motion to change goes through the same steps of the process. You have conferences and everything else.
Right.
Depending on what you're applying to change on your motion to change, that could be iffy about whether you can get a temporary order or not. Like if you're dealing with support issues, that might be a little bit iffy. But again, when they're dealing with kids and parenting issues, like substantive issues about parenting time and decision making and things like that, if you're applying to change those, on a motion to change, then the same rules apply. You cannot bring a motion for a temporary order to change the final order until you've had your case conference first with the judge on the motion to change. So that's the background and the framework.
Right.
Sometimes you will find yourself in an emergency situation where you've had a recent separation and the parties cannot agree on where the children are going to be living on a day-to-day basis and who's going to be making decisions about the children. That is not that unusual of a situation where you're looking at doing an emergency motion. And again, what we'll do is we'll define it this way. An emergency motion is a motion that you're bringing to ask the court to make an order before you've had your case conference with a judge. It can be in a situation where an application or a motion to change hasn't even been started yet. It could be that you might have a very recent separation and one of the parties is threatening to take the children out of the province or to another
Right.
country, or that they have already taken the kids and they've disappeared with the kids. So those are the kind of things that are really considered emergency situations where one party feels that they can't wait until they've started the whole process. Sometimes people will have started an application and the other side does something when they get served with the papers because they figure something drastic has to be done. They take a self-help remedy and just grab the kids and take them out of school and hide them someplace or whatever. And so in that case, you've got an application started, but you might be your first case conference isn't going to be for a couple of months down the road.
Right.
So that is generally the situation where you're looking at bringing an emergency motion. And that's when you're trying to ask the court for an order before you've had your first judicial case conference. And the reason it's called an emergency or an urgent motion is because you're asking for a court to make that order before you've had your case conference, which is normally when it would happen. Okay, and as I said, sometimes it can be that you might have had a final order that's in place for many, many years, and somebody contravenes the terms of that final order, like doing something drastic, like they've either taken the kids out of the province and now is telling you they're not bringing the kids back, or they're threatening to take the kids out of the province, or that they've got the kids even just for a weekend and they refuse to bring the kids back. So in that case, you've got a final order that's already in place, but one of the parties has decided for whatever reason that they have to exercise a self-help remedy. And then the other party says, oh my gosh, I got to go to court to get an order. Or the party that really thinks that the kids are at risk with the other parent and they can't wait to get through the normal court process. They might be the one that says, rather than just doing something that might be breaching the terms of the current order they have, they might say, no, I need to get an order changing our order right now because this is not going to be good for the kids. So in order to bring an urgent motion before you've had your case conference, a party has to show why the party cannot wait until you've gone through and started the normal court process to bring your motion.
Can I ask a quick question before you continue?
Sure.
I heard that the courts are very backlogged. So when you bring an urgent motion, how fast are you? How fast will the court hear you?
If you are, and again, we'll talk about the different scenarios and the kind of things like any applications for urgent motions get triaged.
3 hours. Okay.
So the process is you have to bring a motion, which means you use the normal Form 14 notice of
Yes.
motion and a 14A
Yeah.
affidavit.
Yeah.
So in the notice of motion, it tells the court what you're asking for. And then the affidavit sets out the facts and the reasons why the court should give you what you are in fact asking for. If it is an appropriate, really urgent situation,
Yeah.
you can do it without even giving notice to the other side and get
Right.
before a judge on the same day you show up at the court counter with your documents.
Wow.
It can happen the same day.
I see. Okay.
It might be that you are bringing an emergency motion, but it's not a real desperate urgent thing where you have to serve the other party with the notice of motion and the affidavit. And then you'll have that hearing date set when the court staff can make time available. It might be it could be later on the same week that the motion is served and filed, or it might be like within a week. But that's
Oh,
the whole
that's
thing.
good.
Urgent motions or emergency motions are ones where there is urgency or it's an emergency situation. So if you
Right.
do bring one, if you have to serve the other party, you'll probably have it heard within a week. But
Mm-hmm.
if it's an emergency ex parte, you're doing it without giving notice to the other side, you could even probably get it heard the very same day you actually go to the courthouse with your documents.
Oh, okay, that's good.